started for this session, I would like to invite the chairperson of the Network of African National Human Rights Institution, Dr. Joseph Witter, who will be speaking to us about the applause.
Let me acknowledge once again our friend from the Pan-African Parliament. Start with an overview of the mandate and the role of the Network of African National Human Rights Institutions. For most of us in the room here, it will be a repetition, but you appreciate that we are over what some of you may know for the sake of the Pan-African Parliament and other civil society organizations that are here and may not know what NANHRI has done or is about. And so let me start with the introduction to the network. The Network of African National Human Rights Institutions, popularly called NANHRI, was founded headquartered in Nairobi, Kenya. It is a regional umbrella organization for 47 national human rights institutions across Africa. NANHRI's mission is to support the establishment and strengthening of these NHRIs, independent and are effective in promoting and protecting human rights. Again, NANHRI's vision is a continent where human rights are universally respected and protected. It achieves this by fostering cooperation among NHRIs, providing technical assistance, and facilitating dialogue on key human rights issues. NANHRI's core objectives include enhancing the capacity of human rights and governance, and advocating for the protection of vulnerable populations. Now the mandate of NANHRI, the details. NANHRI's mandate focuses on supporting the promotion and protection of human rights across Africa. It ensures that NHRIs and resources to fulfill their mandate effectively. This includes not only enhancing existing institutions, but also supporting the establishment of new NHRIs in member states that lack national institutions. A significant part of NANHRI's work involves collaboration with various partners, including regional and international organizations like the African Union, the United Nations, and some civil society groups. By promoting adherence to the Paris Principles, NANHRI ensures that NHRIs maintain independence and effectiveness in holding governments accountable for human rights obligations. The overall work of NANHRI is to strengthen the capacity of African NHRIs through training workshops, high-level engagement meetings, such as this one, and other platforms. While the capacity building activities focus on the role of NHRIs under the Paris Principles and the Belgrade Principles, other capacity building activities are based on thematic areas as well as needs assessment for particular or group of NHRIs. Then the role and functions of NANHRI. NANHRI plays a multifaceted role in supporting NHRIs and advancing human. NANHRI leads advocacy efforts at national, regional, and international levels, ensuring that human rights concerns specific to Africa are recognized and addressed in global dialogues. Capacity building. Through training, technical assistance, and resource provision, NANHRI strengthens the capacities or the capabilities of NHRIs to address human rights violations and engage effectively in advocacy and monitoring. Knowledge sharing. NANHRI facilitates the among NHRIs through workshops, conferences, publications, enabling NHRIs to learn from one another and to implement successful strategies. Partnerships and collaborations. NANHRI's work is strengthened by its partnerships with regional and international bodies. It collaborates with the AU, the UN agencies, and other global human rights mechanisms to ensure NHRIs have a voice in international human rights discourses. Additionally, NANHRI engages with civil society organizations and academic institutions to enhance its advocacy efforts and to promote human rights research and policy development. These collaborations also allow NANHRI to focus on cross-cutting issues, sustainable development, helping to align national policies with international standards. Now let's look at some success stories or achievements. NANHRI has made significant strides in advancing human rights across Africa through the following. 1. Cooperation with the African human rights mechanisms. To strengthen cooperation, NANHRI signed a Memorandum of Understanding with the African Union Commission in 2016. This led to the creation of the Regional Mechanisms Program, aimed at enhancing NHRI's capacity to engage with regional human rights bodies. The program covers cooperation with several regional entities, including the African Union Commission, organizes activities like the annual policy dialogue, and some of you would have attended that. Like the annual policy dialogue forum, bringing together various stakeholders to discuss human rights issues. We also have the African, and this is supposed to support NHRIs in obtaining affiliate status, submitting shadow reports, and preparing activity reports. NANHRI also organizes the NHRIs Forum during Africa Commission on Human and People's Rights sessions, and this is one of them. With the African Committee of Experts on the Rights and Welfare of Children, NANHRI collaborates with the Committee to Protect Children's Rights, with recent focus on school safety during the COVID-19 pandemic. And with the African Court on Human and People's Rights, NANHRI assists NHRIs in filing information, litigation, and appearing as amicus curiae. NANHRI has also produced a baseline study on NHRI litigation before the court. Other sub-regional mechanisms. NANHRI supports engagements with bodies like Justice, the East African Court of Justice, the SADC Parliamentary Forum. Additionally, NANHRI facilitates NHRI interactions with international mechanisms under the UN human rights system and supports cross-cutting projects. Accreditation of NHRIs, and that is where some of you really see the relevance of. But autonomous bodies established to promote, protect, and advocate for human rights in line with the Paris Principles and the Belgrade Principles. These institutions must be diverse, must have broad mandates, operate independently, and have financial autonomy to be effective. NHRIs are reviewed every 5 years by the Global Alliance of National Human Rights Institutions, GANHRI, the subcommittee on accreditation, to ensure compliance with the Paris Principles. Based on the review, NHRIs can receive A status for full compliance, B status for partial compliance, or no status at all if not compliant. NANHRI supports NHRIs in sustaining or obtaining A status by addressing subcommittee on financial resources and operational autonomy. NANHRI also assists in document preparation, such as annual reports and statements of compliance, and participates as an observer during the accreditation process. And indeed, you all are aware of Gilbert Sebihogo, our executive director. He's not here because he's in Geneva observing accreditation process of the subcommittee on accreditation, because some African NHRIs are being accredited or re-accredited. Additionally, it provides capacity building for NHRI commissioners, induction training, and advocacy with state agencies. As of 2024, 27 of the 47 NANHRI members, that is NHRIs, hold A status accreditation, while 5 have B status. NANHRI continues to provide technical assistance to support the accreditation process. Additionally, NANHRI also organizes high-level induction for new commissioners. In September, last month, NANHRI organized 7 Southern African Development Community NHRIs. The program strengthened their understanding of their roles and highlighted the importance of partnerships with bodies like the AU and the OHCR. Discussions included best practices for election monitoring and strengthening NHRI independence through legal reforms. Sustainable development. NANHRI's work in sustainable development is aligned with Agenda 2030 and Agenda 2063, both adopted in 2015, which are directly linked to human rights into the planning and implementation of these development frameworks. The past 2 days, we have been discussing how we can utilize planning to integrate human rights. NANHRI's strategic plan for 2021-2025 prioritizes enhancing the capacity of African NHRIs to fulfill their mandate and to promote human rights in Africa. In November 2017, during the 11th Biennial Conference, the Kigali Declaration and Action Plan were adopted, emphasizing the essential role of African NHRIs in promoting a human rights-based approach to sustainable development at the national level. And that has been our major mantra when it comes to human rights on the African continent. Defending human rights defenders. Over the last decade, human rights violations have escalated in Africa and globally, with human rights defenders particularly violence, arbitrary arrests, and forced disappearances, often linked to state agencies. In response, the Global Alliance of Nationalists in 2018, culminating in the Marrakesh Declaration, focused on expanding civic space and protecting human rights defenders with a focus on women. NANHRI has conducted a study in 9 African countries to assess human rights defenders' protection under national laws. The study revealed that most countries lack legal frameworks for human rights defenders' protection, except for Côte d'Ivoire. In most of Africa, protection efforts rely on broader constitutional, regional, and international frameworks like the African Commission, the African Charter on Human and People's Rights. So to support human rights defenders, NANHRI has developed tools such as 1. A model law on human rights defenders' protection. 2. A quick reference handbook for human rights defenders. 3. National and regional action plans for implementing the Marrakesh Declaration. And 4. A monitoring implementation framework for NHRIs. Workshops and training sessions tools resulting in multi-stakeholder action plans for implementing the Marrakesh Declaration. In 2024, and Liberia to boost their work on human rights defenders. This initiative, designed to support capacity building activities, has allowed these institutions to improve human rights defenders' protection initiatives. Now, the protection of the rights of vulnerable populations. In 2013, NANHRI began discussions with NHRIs on promoting the rights of vulnerable groups. By 2014, NANHRI, along with selected NHRIs, started developing a monitoring guide to ensure that NHRIs could observe the promotion and protection of the rights of persons with disabilities, aligning with the UN Convention on the Rights of Persons with Disabilities especially Article 33. NANHRI has also been actively involved in protecting the rights of LGBTQI+ community. NANHRI launched the SOGI, that is the Sexual Orientation and Gender Identity and Expression project, in 2016, following the adoption of the Africa Commission on Human and People's Rights. The project focuses on strengthening the capacity of NHRIs to address human rights violations experienced by the LGBTQI+ community based on sexual orientation and gender identity. Malawi and South Africa have been trained in thematic areas to address these issues. A new phase of the project began in 2021, targeting Liberia, Nigeria, Cote d'Ivoire, Togo, and Namibia. To mark the 10th anniversary of the Africa Commission on Human and People's Rights, Resolution 275, NANHRI held a major event in South Africa in 2024, this year, drawing over 100 delegates from 20 countries. This event highlighted the successes and the challenges in implementing protection for sexual orientation and gender identity. Now, business and human rights. NANHRI has been actively working on the intersection of business and human rights, specifically focusing on sustainable oceans, fisheries, and aquaculture. In collaboration with the Danish Institute for Human Rights, NANHRI launched a 2021 survey to assess the engagement of African NHRIs with the Africa Blue Economy Strategy, developed by the AU in 2019. This survey builds in 2012. The survey findings will guide policy development for engaging NHRIs in business and human rights and sustainable oceans at the national, regional, and international levels. Additionally, NANHRI has introduced a guidebook on business and human rights to provide African regional frameworks and standards, including the Africa Mining Vision and relevant AU conventions. Key questions covered in the guidebook include the relationship between the Africa Union conventions and business and human rights, the action plan for implementing the Africa Mining Vision, and priority areas from the Yaoundé Action Plan. The UN Guiding Principles on Business and Human Rights, endorsed by the Human Rights Council in 2011, served as a foundational framework for NHRIs in this area. These principles corporate responsibility to respect them and the need for effective remedies. NANHRI's role in capacity building began with the Yaoundé Regional Workshop in 2011, which resulted in the Yaoundé Plan of Action. The plan emphasizes building NHRI capacity in business and human rights, integrating these issues into their strategic plans, and ensuring collaboration with stakeholders for effective education and sensitization. NANHRI Working Group on SDGs and Agenda 2063, which I happen to chair. For NHRIs to effectively an Agenda 2063 of the African Union as envisioned by the Kigali Declaration, NANHRI established the NANHRI Working Group on SDGs. Among other issues, the working group was tasked with ensuring sharing of experiences and good practices between and among the African NHRIs in monitoring and contributing to the implementation of the two agendas at the national level. Members of the working group on SDGs include the NHRIs of Ghana, Kenya, Malawi, South Africa, Cameroon, and Sierra Leone. Challenges facing NANHRI and NHRIs in Africa. Despite its successes, NANHRI and its member institutions face several challenges. 1. Limited resources. Many NHRIs struggle with inadequate funding and technical support, which hinders their ability to fulfill their mandates effectively. Political interference. In some countries, NHRIs face pressure from governments, compromising their independence and effectiveness in advocating for human rights. Public awareness. There is often limited public engagement. Citizens are not fully aware of their rights or the role of these institutions. Finally, future NANHRI is focused on expanding its advocacy efforts, particularly on emerging human rights challenges, such as climate change and digital rights. Additionally, NANHRI is working to ensure the sustainability of NHRIs by strengthening resource mobilization and enhancing their capacity to engage with regional and international human rights mechanisms. Strategic priorities for the coming years include increasing membership, raising NANHRI's visibility in global fora, and improving internal systems for monitoring and evaluation to ensure impactful human rights advocacy across the continent. On that note, I wish to bring the overview of the mandate and the role of the network of African National Human Rights Institutions to an end. Thank you so much.
Can we please give the chairperson another round of applause? NANHRI, and as we can see from his presentation, so I'm going to speak slowly. I remember the interpreters were struggling to catch up with me. Hi. So from Dr. Whitta's presentation, clearly we can see that NANHRI operates at the regional body. It's a combination of 47 national human rights institutions, and he had spoken to some of the role that NANHRI plays in coordinating these 47 national human rights institutions, and particularly in providing institutional support for the national human rights institution. Now, having looked at the regional amalgamation of national human rights institutions as per the presentation, we will now proceed one step further by looking at the national level and specifically looking at the overview and mandate of national human rights institutions. And to give us this overview, I would like to invite Ms. Ruth Sekedi, who is the Director, Monitoring and Inspection of the Ugandan Human Rights Commission. Can we please give her a very wonderful round of applause?
You all. Thank you for giving me this opportunity to give an overview of how NHRIs work. NHRIs, I mean National Human Rights Institutions. Ladies and gentlemen, national human rights institutions are very key in the protection and promotion of human rights work. The UN, in its wisdom, observed that states alone that are the primary duty bearers cannot do this work alone. So they then decided that we needed, or the world needed, institutions that were the watchdog of the state and yet independent of the state. The UN, in its wisdom, thought it important that every government, every state should have an institution that is the custodian of human rights and would be able to be the watchdog of the state to protect human rights. So national human rights institutions are state-mandated bodies, though independent of government, with broad constitutional and legal frameworks to protect and promote human rights. It's very important that I start with this, because many times I'm glad we have civil society in the room. The question of independence of the NHRIs comes in, and that is why we have dealt with the Marrakesh Declaration and the Accra Declaration that compels offenders. Ladies and gentlemen, NHRIs, I think, like the chairperson has just spoken, are state-mandated bodies. They are creatures of law and constitution, and they should be. But then at the same time, they're expected to be independent of government. Many do not understand this context. How do you separate an NHRI from the state that actually establishes it? Yes, it's a creature of law, but it should be independent in the way it does its work. And that is why during the review by NANHRI, we are scrutinized on that independence. NHRIs are supposed to have a very wide mandate. So we're supposed to work on all rights, including economic, social and cultural rights, civil and political rights, cultural rights, issues of environment. You have heard of business and human rights, and all other rights as well as environment. NHRIs come in at least 5 forms that are known. Majority are what we call National Human Rights Commissions or Human Rights Commissions. And I think majority of our NHRIs have human rights commissions. We have the human rights ombuds institutions. These ones are usually headed by one person with a secretariat. Then we have consultative and advisory bodies. These ones simply advise. Those ones are usually found in Europe, like the National Institute for Human Rights. These ones are also usually found in Europe. Apparently they don't have so many human rights issues. So they are just advising the states, and also they work on publications and also coming to Africa and Asia to support us. Well, we welcome this and we're happy to have that. Then we have the hybrid institutions such as Ghana, and they have it's a merger of the ombuds institutions and the Human Rights Commission. So, so you realize that institutions like these hybrid are very broad. They are big in their mandate. So these 5 are the clusters and categories of what NHRIs look like. I work. So what are the mandates? What is the mandate of NHRIs, since we have talked about having a very broad mandate? One of the mandates that NHRIs have is advisory, advising the state on matters of human rights. And this means that every situation that happens in our countries, NHRIs have to be able to give it a human rights lens and advise the state. Now, the advising means advising government, the executive. It means advising parliament, the legislature. It means advise, for example, Ministry of Education, what are you doing? And I'm giving the context of Uganda. When COVID hit, we started writing letters to Ministry of Education on how they have to handle the situation to make sure that children can continue with education while at home. We then advised the Ministry of Health on how they can address issues of healthcare and providing health services to the people in the context of the limitation of COVID-19. We continue, as NHRIs, we continue advising ministries, departments, and agencies on the work they do in the context of human rights. NHRIs are supposed to monitor the human rights situation in the country and report. Reporting is very important because you cannot talk about human rights without documenting, giving evidence on the findings of the human rights situation. So NHRIs are required to prepare special reports and annual reports and submit the same to Parliament. The submission of these reports to Parliament is very important because Parliament is supposed to be a representative of the people. And as such, it's supposed to be independent. So your independence is you report to Parliament and not to the executive. And so it's very important that you draw a line in regard to the situation in the country. Which reports are usually used by treaty bodies or treaty body mechanisms to track the progress of human rights implementation and compliance by the different states. NHRIs also visit places of detention. Nelson Mandela has said we assess a country's human rights observance on not how it treats its highest citizens, but on how it treats its lowest citizens. And places of detention as a place where you have lost it all and your only trust is with the person or your protector, and that is the prison warders. So we are required to monitor regularly and unannounced places of detention. And places of detention, I mean prisons, police cells, military detention places, intelligence cells, and any other place where you feel or the NHRI feels persons are being detained, as including psychiatric institutions and hospitals, because people don't go to hospitals because they want, and many are out of their mind by the time they're taken to hospital. So it's a requirement that we visit hospitals to make sure that these people are treated with dignity. NHRIs also monitor the human rights situation in the country and advise on compliance or with international laws and practices with international human rights norms. So this means that we have to advise government on everything, on regulations, on policies. We review bills before Parliament. We review laws and assess whether they are compliant, and then we recommend for amendments. Yesterday we were talking or laws, the English background laws. And this means that we have that mandate to point out to the executive that this law contravenes or goes against the standards of human rights principles and norms. Then NHRIs are required to provide support, receive and investigate complaints on human rights violations. Now, the investigatory arm is such that not all NHRIs have it, but it is a requirement that if you can receive complaints, you may need to monitor. So majority of NHRIs have quasi-judicial powers to receive, investigate, mediate issues of human rights or complaints of human rights violations. And a majority of the NHRIs, or some, have taken up the amicus and have taken cases before court as amicus. We only have one NHRI that has a human rights tribunal, and that is the Uganda Human Rights Commission. And as a commission where I come from, I'm so proud of our tribunal because then we're able to give redress. It sits as a court of law, chaired by the chairperson, Uganda Human Rights Commission, who's seated over there. And it sits as a panel. So it is the only one in the world. I think Kenya tried, and then it was shut down by courts of law. But for us, we have ensured that, yes, we have ensured that the members don't get involved in the process prior to receiving the complaint at the end to adjudicate these cases. So it is a thin line, and we are happy that the judiciary is excited that we reduce their backlog by addressing these cases. So it's the only NHRI that does that. Majority of NHRIs, however, receive, investigate, mediate, and then they refer complaints of human rights violations. It's very important that victims of human rights get redress. So it's very, it's one of those, the quasi-judicial power is very important. NHRIs are supposed to give legal assistance to victims of human rights violations. When people feel that we are relevant and come to us with questions of law on matters of human rights, and we give them, we build our confidence. We build, you know, they then have confidence in us because they come to us with so many solutions. And because we have a big mandate, we get sometimes a backlash. We get so many questions because many times, if all you have is a hammer, you end up looking at all your problems as being solved with a hammer. And that is what the public sometimes does. It looks at these institutions, NHRIs, as the ones to solve all state problems. Issues of women, issues of children, issues of torture, issues of death, murder, issues of water, issues, because they are human rights issues. And as such, the public then comes out and and all they have is a hammer. So if the only tool you have is a hammer, you tend to see every problem as a nail. So they look at NHRIs as the nail to hit. We are supposed to find, so that is why NHRIs have to build a bridge between civil society, the executive, the legislature. We can't do the human rights work alone because it means we do everything. Whether it is access to healthcare, access to education, issues of climate change, issues of business and human rights, issues of women, issues of children, issues of persons with disabilities. Every issue in our country or every issue around you is a human rights issue, including poverty. So we can't afford to do this work alone. We have to work with the state, we have to work with civil society, we have to work with development partners in order to fulfill our mandate. NHRIs also have to do research. We are required to do research and publish reports where we also make recommendations, give opinions. We have to sensitize and create awareness of human rights because people cannot claim what they do not know. They cannot, and then we can't also give what we don't have. So for people to be able to assert themselves and claim for their rights, it's very important that we conduct human rights education, human rights awareness. Now that is usually very expensive. It means we have to use the different media platforms. It means we have to use the televisions, the radios, we have to use X or Twitter, we have to go on social media platforms, okay? Sometimes, so even the message sometimes is not understood, but we try, and we're supposed to continue trying. With news, news reporting, we're supposed to provide reports. We are supposed to devise mechanisms that fit within our country contexts to create awareness. You have to look at your population. Is it a young population? Is it an old population? Is it a literate population? Now, the Uganda Human Rights Commission has a Human Rights Museum. I think it's the only museum among NHRIs. Why? Because we realize that people are visual. And because they are visual, they want to see how do you explain human rights in a different form without necessarily using the usual way of words, the usual way of lecturing to the people. So then we brought in place artists to portray human rights in pictures and videos and sculpture. It's very interesting to see, okay? So we as NHRIs have to be innovative and modern and look at our country context to see what is it that will inform our people. Someone can see a picture of mothers dying, a pregnant mother, and then they say, oh, this is also a human rights issue. So we need to devise mechanisms of sensitizing, creating awareness in many different ways to be able to capture the different groups. We are supposed to cooperate. We're supposed to cooperate with NGOs or civil society organizations. We're supposed to cooperate with state actors. We're supposed to cooperate with non-state actors, the public, local government. We are supposed to work with regional mechanisms and the international mechanisms. And I think I have stated this. NHRIs cannot work in isolation of all the other institutions around us nationally. It's a requirement that we work with civil society. And civil society are many, they are broad. You have those working on freedom of expression, you have those working on torture, you have those that working on women's rights, children's rights, persons with disabilities. So you end up having a list of civil society you have to work with. So what did we do, or what do we do? We are then required to cluster our partners. So we have lists of, okay, if it's children's rights, these are the civil society that we have in the country. These are the regions where we find them. And this is the work we have to do with them. If it's about the right to health, who works on health? That's why when you map, you do a stakeholder mapping, it's easy to relate. But we have found that sometimes the NHRIs have 1 or 2 or 10, a group of 10, but you can't do that because the thematic areas of human rights are many, they are different, and they call for different expertise. Now, why partnership is also important is that civil society sometimes may have more funding than the NHRI. But when they are your partner, you can do these activities together. You bring their expertise and they bring their resources. Or you merge the resources and at the end of the day, you all achieve one desired goal. So partnership is a requirement, and during accreditation, we note that partnership is also considered. That NHRI also are required of rights, because as Africans and as human beings, we have our perceptions, we have our attitudes. So we have our cultures. So we need to inculcate and instill a culture of human rights observance. And this is through training, awareness raising activities, and a variety of issues such as right to adequate housing. I mean, how many of us talk about adequate housing, and what does adequacy mean to an ordinary person? If we're talking about access to education, what does it mean? Okay? Is it available? Is it accessible? Is it acceptable? Is it affordable? And what are these variables? What do they mean to an ordinary person? So the NHRI has to break it down for the Ministry of Health or Ministry of Education to say, for you to make sure that you're providing effective health care, you have to ensure that the quality of goods is at this rate, or the education is at this rate, and so many children can access it, and the walking distance from every home should not exceed this. So you break it down and guide and advise the different ministries on what the right to education, the right to health, the right to freedom of assembly means, by bringing out the standards and breaking it down based on the ingredients of every, to inform the policies or the action plans that they may have. NHRI is also required to support human rights defenders to combat issues related to violation of human rights. So, am I running out of time? So let me conclude. So the mandate of the NHRI is really wide, and it is provided for by the Paris Principles. These are the principles relating to the status of national human rights institutions. And these Paris Principles are the guide on the mandate of NHRIs. And I think the other issues were raised by the Commissioner. He guided. I thank you for listening.
Can we please all once again give with a very wonderful applause? Maybe just to provide a bit of context as to why I would ask for one more applause for her. So this was a very impromptu presentation, because we had issues with some of our participants that were supposed to come in today. We had issues of flight delay, and within less than 12 hours, she managed to come up with that presentation. Please, now, thank you very much, Ruth, for that presentation. I think from the presentation, what we are also starting to see is how the unique status of NHRIs as a state-created institution, but also independent institution that is expected to hold states accountable, also creates confusion with regards to the public expectation. And I think also what comes out from that presentation is also the fact that NHRIs are also victim of the broad nature of human rights. I think it is not out of place for the public generally to think of human rights as that phenomenon that solves almost all of the problem. And now with NHRIs with broad mandate for the protection of human rights at the national level, that expectation is now put on NHRIs, and with that comes a lot of burden on NHRIs to deal with that challenge. But of course, we can also pick some lessons from some of the innovation that she specifically mentioned with regards to the Uganda Human Rights Commission, like simple things like visualization of human rights and how that could also help with regards to how NHRIs perform their function, and most importantly, leveraging on collaboration with development partners, with civil society organizations for expertise and also resources. Thank you very much, Ruth. With that, we would move to the final institution that will be involved in this role of the Pan-African Parliament. I would like to invite to the podium Honorable Jane Marin, who is the chairperson of the Human Rights and Justice Committee of the Pan-African Parliament. Can we please give him a round of applause?
Merci beaucoup. Il est très difficile de se prononcer après les deux orateurs qui nous ont bien présenté leur conception, leur travail, mais aussi les expériences que nous avons entendues, nous ont plongé nous ont vraiment égayés. Et à présent, sans trop tarder, je vais vous entretenir sur le rôle, le mandat, les fonctions du Parlement panafricain. Vous le savez bien, le Parlement panafricain est l'un des organes de l'Union africaine qui a été défendre les voix des peuples et des parlements d'Afrique et pour assurer leur pleine participation aux affaires de l'Union. Et le pape, en tant qu'organe législatif, normalement, est investi des attributions comme fonction consultative, parce qu'aujourd'hui, le protocole de Malabo n'est pas encore ratifié. Normalement, on devrait être un organe législatif. Mais, faute de cet instrument, nous restons un organe consultatif. Mais aussi, nous avons des fonctions budgétaires, fonctions de contrôle. À titre d'information, pour l'Union africaine, vous savez, nous avons différents organes, les organes politiques, donc l'Assemblée de l'Union, Conseil exécutif, Comité des représentants permanents, Comité technique spécialisé, mais aussi le Conseil de paix et de sécurité. Tous ces organes collaborent bien, comme le Parlement panafricain, Conseil économique, social et culturel, le Conseil consultatif de l'Union africaine sur la corruption. Mais aussi, il y a des organes judiciaires et techniques, comme la Cour de justice et droits de l'homme, établie à Arusha. Mais aussi des organes financiers, Banque africaine d'investissement, Fonds monétaire africain et aussi la Banque centrale africaine. Donc ce sont des richesses de l'Afrique. C'est juste à titre d'information. Quels sont nos mandats au niveau législatif? Le pape contribue à l'élaboration des traités de l'Union africaine, fait promouvoir la ratification, la mise en œuvre et application des traités de l'Union africaine. Le pape aussi propose un modèle d'instrument juridique, le commande des réformes juridiques ou une législation spécifique. Mais aussi au niveau, comme je l'ai dit, au niveau du budget, le pape devrait normalement fournir des recommandations sur le budget de l'Union africaine, mandater les membres du Parlement panafricain de s'assurer que le budget national dispose une allocation appropriée pour la mise en œuvre des décisions et il y a des implications financières. De supervision, donc aujourd'hui, c'est la supervision souple parce que tous les pouvoirs ne sont pas à notre disposition parce que le protocole de Malabo, pour être mis en vigueur, pour être opérationnel, devait connaître 50 plus 1, c'est-à-dire 27 plus 1, 28 pays, 28 ratifications. Et aujourd'hui, nous sommes uniquement à 15, après c'est la Centrafrique qui est le 15e pays. Ouais, donc devrait examiner toute défaillance de mise en œuvre, inviter les États membres et organes à prendre des mesures nécessaires, charger les membres du Parlement panafricain de poser des questions orales ou écrites aux autorités nationales responsables de prendre les mesures qui s'imposent. Mais aussi, en tant qu'organe de représentation du peuple, le pape déploie des parlementaires pour jouer le rôle de diplomatie parlementaire, plaidoyer, des visites aussi promotionnelles et de sensibilisation, ainsi que le renforcement des capacités des députés sur la mise en œuvre des questions qui nous intéressent. Les organes du pape, à titre d'information, sont la plénière, le bilan et 11 commissions permanentes. C'est pourquoi ici, je suis ici en qualité du président de la commission des affaires juridiques et des droits de l'homme et je en même temps représenter le Parlement panafricain. D'autres structures existent également pour soutenir et faire les journaux. Donc, comme vous le savez, chaque région a la chance de se réunir, d'échanger sur les questions qui rentrent la région. Nous avons 5 caucus régionaux. Il y a aussi les caucus thématiques, comme le caucus des jeunes, le caucus des femmes aussi. Oui, nous avons aussi le secrétariat. Le système de travail du Parlement se repose sur les commissions, des commissions à la plénière. Parmi les résultats obtenus figurent des résolutions, des recommandations, des déclarations et des instruments juridiques d'harmonisation tels que des lois types. Parce que le pape a déjà, jusqu'à aujourd'hui, proposer à l'Union africaine et aux États beaucoup de lois types. Le pape aussi entretient des liens étroits avec les parlements, que ce soit les parlements nationaux, régionaux. Comme vous l'avez toujours vu, des fois, on accueille des représentants des parlements régionaux qui viennent nous présenter les préoccupations, mais aussi les progrès dans le travail. Grâce aux travaux de la plénière, le Parlement panafricain a enregistré des principales réalisations sur l'action de plaidoyer pour la ratification et la domestication des traités sur les valeurs partagées de l'Union africaine, protocole de Maputo, convention de l'Union africaine sur la prévention et la lutte contre la corruption, protocole de la Cour africaine, convention de Kampala, donc convention pour la protection et assistance aux personnes déplacées en Afrique. Il y a aussi la charte sur les valeurs et les principes du service public et de l'administration. Des missions d'enquête parlementaire réussies qui ont contribué à améliorer la situation politique, sécuritaire et humanitaire dans plusieurs États membres de l'Union africaine, tels que la République centrafricaine, le Soudan, la Côte d'Ivoire, la République arabe-sahraoui, le Tchad et le Burundi. Aussi, il y a la contribution parlementaire à la formulation et à la promotion de la position de l'Union africaine dans diverses institutions internationales, telles que la conférence des partis, donc la COP, conférence des partis, donc aussi des réunions de l'Union. Autre réalisation, il y a eu la mise en place et l'enforcement des réseaux et des synergies avec les parlements nationaux et régionaux, les communautés économiques régionales, les organes interparlementaires, les universités et les organisations de la société civile sur les questions de droits de l'homme et de gouvernance. Au Parlement panafricain, dans chaque session, nous avons vraiment la chance d'avoir des universitaires, des scientifiques, qui nous entretiennent pour différentes thématiques. Et vraiment, nous sommes contents parce que pas mal d'universitaires viennent comme consultants nous entretenir, nous enrichir, parce qu'on ne donne que ce qu'on a. Si on n'a pas de connaissances requises sur certaines situations, sur certaines thématiques, il est difficile aussi d'aller faire le plaidoyer, d'aller aussi faire les consultations au niveau national sans que vous ayez des outils adéquats. Et le succès de la diplomatie parlementaire a permis, entre autres, la levée des sanctions économiques contre les États membres de l'Union africaine, ce qui a allégé la situation socio-économique des populations concernées. Engagement et résolution sur des questions critiques affectant l'Afrique, telles que la lutte contre le terrorisme, les flux financiers illicites, la paix et la sécurité, la gestion des ressources naturelles, le changement climatique, la libre circulation des personnes et des biens, la bonne gouvernance, la transparence et la responsabilité, les droits des personnes vulnérables, les droits des migrants, la mise en œuvre effective de l'agenda 2063. Pour toutes ces situations, même la session qui vient de se passer, nous avons eu beaucoup de présentations qui ont bien enrichi. Les parlementaires ont intervenu pour enrichir les débats. C'était vraiment très intéressant. Aussi, nous faisons la coordination et l'harmonisation des législations des États membres par la formation, le renforcement des capacités, la conférence annuelle des présidents. Même la session passée, il y avait les présidents des chambres étaient là. Plus d'une vingtaine ont répondu à l'invitation du Parlement panafricain. C'était très intéressant. Donc, du 20 au 22. La coordination et la conférence annuelle des présidents, la réunion annuelle des secrétaires généraux, la formulation des modèles de loi type. Certains instruments juridiques, comme je vous ai parlé, appelés loi type, ont été adoptés par le Parlement. Ici, on notera quelques-uns, à savoir loi type de l'Union africaine sur la réglementation des produits médicaux, loi type de l'Union africaine sur la protection du patrimoine culturel, loi type sur le maintien de l'ordre en Afrique. Il y a aussi loi type sur le handicap en Afrique. Il y a aussi la loi type sur la non-double imposition, loi type sur la sécurité alimentaire et nutritionnelle, aussi loi type sur les coopératives. D'autres instruments vont commencer pendant les sessions qui vont suivre. Ici, on note là, par exemple, la loi type sur l'égalité entre les hommes et les femmes en Afrique. Il y a aussi loi type sur la patridie, loi type sur la facturation, loi type sur la gestion des sols. Donc, sur la gestion des sols, nous l'avons déjà commencé et nous sommes à une étape satisfaisante. Et loi type sur la mise en œuvre des décisions rendues en matière de droits de l'homme au niveau national. Ça, c'est très important. Ça nous concerne tous ici. Nous devons y apporter des contributions pour que nous puissions vraiment aller de l'avant sur la loi type sur la mise en œuvre des décisions rendues en matière de droits de l'homme au niveau national. Parce que ici, on éprouve beaucoup de difficultés, mais aussi la Cour africaine des droits de l'homme nous a dit, on était à Arusha, la commission de justice avec nos autorités au pape, le bureau, le président et le deuxième vice-président du Parlement panafricain. On était là, nous ont dit vraiment que même les décisions prises ne sont pas acceptées, ne sont pas mises en œuvre. Donc les réparations ne sont pas... Donc il y a un tas de problèmes dans notre domaine. Et aussi la loi type sur les changements climatiques a été proposée et la commission est en œuvre pour aller de l'avant. Le pouvoir et fonction du pape aussi, notez là ici qu'on fait des règlements intérieurs du pape. On peut classer les pouvoirs et fonctions du pape en 4 catégories. Comme je les avais dit, les pouvoirs consultatifs, pouvoir de discuter par ses propres initiatives et d'exprimer un avis sur toute question relative à l'Union africaine, aux organes de l'Union africaine et à tout État membre. Le pouvoir consultatif aussi, le pouvoir de discuter, de prodiguer des conseils sur toutes les questions à la demande des organes de l'Union africaine ou de tout État membre. Pouvoir de contrôle, le pouvoir de superviser l'élaboration et la mise en œuvre des instruments politiques et programmes de l'Union africaine. Aussi, comme pouvoir budgétaire, je l'ai cité là-bas, pouvoir d'examiner et de débattre du budget de l'Union africaine et de faire des recommandations à l'Assemblée. Ce pouvoir nous est ôté aujourd'hui parce que, comme je vous ai dit, nous n'avons pas tous les pouvoirs faute de la ratification du protocole de Marabon. Les questions africaines à examiner par le pape ont trait dans les divers instruments, décisions et déclarations adoptées par l'Union, appelées valeurs africaines partagées, qui comprennent la bonne gouvernance, l'état de droit, la paix et la sécurité, la démocratie et les droits de l'homme. Dans l'exercice de ces missions et compétences, le Parlement panafricain peut notamment initier ou participer à des missions d'observation électorale. J'ai été un jour honoré d'aller au Libéria. Les élections au Libéria, j'étais là. J'ai été honoré. Donc c'est d'actualité alors ces missions. On participe aux missions électorales et à d'autres missions d'enquête dans les États membres de l'Union africaine. Oui, on peut aller même dans le domaine économique, bien pour voir la mise en œuvre l'état de mise en œuvre de la ZILECAF. Je sais, il y a une émission par exemple qui va aller en Tanzanie, voir les ports, certains ports comment on fait les transactions, comment les facilités sont faites. Donc on fait des missions pareilles. Et demander des informations aux autres organes de l'Union africaine sur toutes questions relatives à l'Union africaine et les autoriser à faire des déclarations au cours des sessions. Recevoir des représentations ou consulter le peuple africain et la diaspora. Adopter des recommandations et des résolutions sur toutes questions débattues. Si vous allez sur le site du Parlement panafricain qui se sont déroulés. Et pour la suite, l'article 3 du règlement intérieur prévoit que les organes du Parlement on l'a déjà cité, donc les commissions permanentes, le bureau, oui. Et d'autres structures existent également pour soutenir et faire progresser les missions du bureau et des commissions permanentes, je les ai citées. Et le travail du Parlement qui débute au niveau des commissions se termine en première. Ça, c'est très important. Quand j'ai échangé avec mes collègues ici, pour que nous puissions avoir un cadre de collaboration avec les institutions de protection des droits de l'homme, comme nous l'avons déjà fait, parce que pour le moment, nous avons défini le cadre de collaboration avec la Cour africaine des droits de l'homme, mais aussi la Commission africaine des droits de l'homme et des peuples ici qui est ici à Banjul. nous avons déjà défini les cas de collaboration où on montre bien les domaines clés de collaboration. Pour les institutions aussi, sont les bienvenus. Donc le travail se termine en plénière par l'adoption de résolutions ou des recommandations. Chers camarades, chers participants, c'est par ici que je termine mon allocution tout en vous demandant de travailler, de bien collaborer avec le Parlement panafricain. Toutes les institutions devraient bien collaborer avec le Parlement panafricain pour que nous puissions avancer notre agenda. Je vous remercie.
Thank you very much, Honorable Jean, for that presentation and for opening the Pan-African Parliament to our participants and giving us that background information. I think what is coming out strongly is some of the commonalities in the challenges of the two or the three institutions in this regard. What comes out strongly from your presentation is the limitation as it stands of the Pan-African Parliament to play its role as a legislative organ because of the lack of ratification of the Malabo Protocol. And I think even before we go into issues of developmental agenda, that already tells us that there is the need for us in this room as national human rights institutions to encourage accede to the Malabo Protocol to allow that protocol to come into force so that the Pan-African Parliament can actually play its role. But that limitation, you have the different institutions. Now, having listened to the three presentations, I will... Okay, so we'll take your intervention.
Thank you to the professor. Thank you to our esteemed overview of the institutions. My area of class, part of the assessment of the independence of an NHRI is its ability to report directly to Parliament. The NHRI reports to Parliament through the Ministry of Justice and Constitutional Affairs. In Uganda, does the NHRI report directly to Parliament independent of the line ministry? Secondly, you speak about the collaboration with state and non-state actors. So in my country, we have similar institutions that we share common that we have faced in the past couple of years, is that in our collaboration or in pursuing the work that we do, we seem to be in direct competition with these similar institutions, yet we receive from the same source in terms of resources. So I would like to get your insights in that, on how best we can manage that, so that we are seen as a key player to directly impact the improvement of human rights in the country, than to be perceived as competition among similar institutions. Thank you.
Thank you very much for that intervention. I see the Deputy Chairperson of the Zimbabwe Human Rights Commission. Please make your intervention.
Thanks very much for the presentation. Mine is not a question, but it's a take-home from the roots. I definitely will take that home, and I will push that in Zimbabwe we also have that kind of a museum.
We can already see how we are learning best practices. If there are no other intervention, Dr. Ambrose, please make your intervention.
Thanks so much, moderator. I thank the panelists for the presentations. maybe just have one for the Lord, especially to an African presentation. Yes, you mentioned one of the key challenge in the ratification, but probably you could highlight in what ways the NHRIs can support in this, maybe deeper a bit, so that since they are representing the countries here, they go aware and they are able to support in the process. That's one. Two, you could also probably be the Pan-African Parliament, especially in ensuring effective monitoring of HR conditions. Yeah, those are my two concerns, which I feel you could touch on, and then we'll go smarter as we go back to our respective countries. Thank you.
Thank you very much, Dr. Ambrose, for that question. Honorable Patricia.
Thank you very much. My question is for Ruth. She made mention about the tribunal sittings in Uganda, which, of course, I've seen when we visited Uganda. They showed it to us. But you also made mention that a lot of tribunals across NHRIs are not effectively functioning, or they've actually gone defunct. So I would like to know, maybe you can share some best practices on what has kept yours effectively running till date. Thank you.
Thank you very much for all of this information. I think at times best practices also put you on the spot, and you have to explain some of your best practices. So Ruth, over to you to elaborate further on your beautiful presentation, and I'll respond.
My chairperson here, since he has the NHR, the network, to also add his voice. The first question was about the competition with other state institutions. I think there is room for all institutions. Unfortunately, due to limited resources, we can end up having an overlap of institutions or mandates. I'll give an example that Uganda has an Equal Opportunities Commission. Now, when you look at the UDHR, the cardinal or cornerstone of human rights is equality and non-discrimination, right? And everything that we deal with, whether it is health, whether it's education, whether it is torture, it is about equality and non-discrimination, because it's the cornerstone of human rights. It's on equality and non-discrimination on which all human rights are anchored. And yet, government in its wisdom decided to establish an Equal Opportunities Commission to be able to help marginalized communities, including women, children, persons with disabilities, indigenous persons, to help them address their rights. We accepted that. So what did we do? We have a mandate. And if you look at what they established, it was very similar to what we have. They had monitoring, they had complaints and investigations, they had civic education and human rights education, very similar to what we have. And we supported them in that. However, we agreed that what they do should be tweaked to address only issues of equality, non-discrimination, and matters of gender. And that is what they did. So we decided to partner with them. Because human rights is so broad, there's room for all of us, there's no need for competition. As we speak right now, government is going to realize what it had done, and the splitting of hairs and splitting of resources, they realize it's not feasible. So now they have started a process of restructuring and merging. So we're in a process of merging the equal opportunities back to the commission, and we welcomed it. And so this merger and restructuring will bring that component, which is also a human rights component, back to us. But then it's also not about even at these NHRIs, but even with state. You realize that when you're dealing with Ministry of Gender, They are working on issues of all of us. We can complement each other, we can support each other, because whatever we do is for the good of our nation and our people. So we look at them not as adversaries, but as partners. So when we are mapping up, they become key partners on whatever area they're working on. So we always use the expertise as well. And then, so you said how best to manage the competition by making them partners. Then you realize that sometimes they have resources and you don't have. So use their resources. Because you have partnered, they say we're organizing a workshop, do it together. We are going to monitor, you don't have money, we say, but we shall send our staff. Who has benefited, both of you, because you're also reporting it as an achievement. You're producing a publication, you have your names, EOC, UHRC. Whose report is it? For both of you. Do you understand? So look at them and deal with them as partners, but not adversaries, because there's so much space for each of us in the human rights space. And then, Madam Chairperson, you asked about our tribunal. If my chairperson was not seated on the other side of the hall, she would have answered this best, but I know she could want to add a word or two. Now, the tribunal is a key component for our commission. And the tribunal is, remember, to be a chairperson, you must be at the level of a high court judge. Meaning you have to adjudicate cases. You have to have the capacity to adjudicate cases. Now, there are also rules and guidelines on how a tribunal should be run. And the way it is run, it is also anchored onto the processes very similar to a court. Okay? So the hearing is the best. They have the establishment of the NHRI and the mandate. They don't have that mandate of a tribunal. So it is the only NHRI that has a legal mandate to have a tribunal. And the hearing follow that process of a court process. The presentation, you know, but we make sure that it is free of charge. The lawyers of the commission deal with the complainants and they represent these people. And then there is cross-examination, re-examination, and the whole process, the way it is done in court, only that it is toned down and it is not as rigorous as the ordinary courts of law. Because you're dealing with indigent people, we usually deal with the poorest. I would want my chairperson to say a word. Allow me, madam, to ambush you before the chairperson of the... Sorry? Yes, since she heads the tribunal. In Uganda, we say you don't speak for the living, you only speak for the dead.
Complainants we get are those who cannot afford to take their courts to courts of judicature. Those which will require them to pay filing fees, for instance, to hire and pay lawyers, together with the attendant costs of what they call disbursements. So it's not easy to eradicate something very popular with the people and which is anchored in the Constitution. But let me use this, I hope I satisfy you. Okay. Let me just use this opportunity to request all of you here to stand with the Uganda Human Rights Commission, to support us in any way you can, who is facing attacks and isolation back home, and which attacks are likely to continue. Because of the stand we have taken to respect, to promote the rights of everyone. It's not okay that any parliament wakes up to legislate away a whole section of people, to declare them banned, and yet these people are among us. They come to us, we meet them, to enact a law to wish a community, an entire community away, unless we are talking about extermination. So we decided to begin speaking out against that. I don't know whether you understand what I'm saying. Yes, there was a private member's bill moved by one of the members of parliament, which resulted into rapid enactment. This was the law which was the fastest to be enacted in the history of Uganda, where there was no opposition, there is no government side. It was unanimous. It was passed in record time. The Uganda Human Rights Commission is usually invited to present views on every bill in Parliament, to present the human rights implications of any bill. This time we were not invited. We came out to say this law has the following consequences. And for that, you don't wish to be in my shoes. That's why I'm saying I need your support, I need your prayers. This morning I got a message of support from Martin. So even an email telling me, Chairperson, be firm, we are with you. NANHRI is with you. Sierra Leone stands with you. That will be something. That's what I wanted to share. I'm not a very popular person. I used to join the majority in wishing away people who come to me, who call me, even when I'm here. Yes, who interact with me, who tell me, here I am facing a trial in this court. And I send my team, and indeed they establish there are 4 young men who are facing a trial for what I call a victimless crime. These are adult young men who are dating each other. And you take them to court. We say, no, this shouldn't happen. So, but something very serious is happening. And the threats keep flying in. The more reason, thank you for giving me this opportunity to request you for your support. Thank you.
Thank you very much, Chairperson, for that very candid call for solidarity and support. And I think every one of us in the room have heard you, and definitely we would show our support in whatever way possible, because these are also some of the issues that we talk about with regards to backlashes that National Human Rights Institution get for simply performing the mandate that has been assigned to them by law. Of NANHRI to just complement the discussion, and then we can take Honorable Chief.
Thank you so much. Because of the work I have done in Eswatini, I'd like my colleague to just kindly get the context so that you don't know, then I can make a comment. You talked about you want to let us know, like how in other countries we know who may be competing with who, so that we can tailor the answer or the comment.
Thank you, Chairperson. So in Eswatini, I think as you know, that we have a hybrid mandate. Hybrid mandate, just like the Ghana Commission. And there we have an anti-corruption agency that was established by legislation outside of the constitutional framework. Secondly, we have a disability unit, social security agencies that are housed under the Deputy Prime Minister's office. they all deal with human rights issues, even gender as well. So in that space, you find that there is many intersections in terms of the work that we do. And at some points, the Commission is perceived to be encroaching when you are dealing with now with, for instance, the children's rights matter, which falls squarely within the mandate of the Deputy Prime Minister's office. And it may seem that despite the establishment of the Constitution, the government, in its wisdom, as Ruth has said, chooses to continue assigning these human rights mandates to the Deputy Prime Minister's office and other places perceived as competition, yet we are a constitutional body that is mandated to be dealing with these issues.
Right. I think that is the context I wanted you to frame it, because within that context now, yours is a bit peculiar. It's not like the normal mandate overlap or creeps that Ruth would have mentioned. Now, because the UN system made my commission to go to Eswatini, I don't know whether you are aware of it. We have come to Eswatini. We've done some consultancy on the issue you have mentioned. And we've submitted a report to the UNDP, who really wanted to engage government to see how you would overcome this issue, where I don't know how to phrase it. We were also a bit surprised when we got there. I didn't come by a constitutional mandate. But without amending the Constitution, there is an attempt through statute to establish an anti-corruption body. That much. And we are wondering, so how do you do that? One, without taking away the mandate that has been given by the Constitution to a particular body, and then you establish one and practically prevent the body that has the constitutional power from performing. And so, because of the political nature of it, we've made our recommendations, and honestly, your Chief Justice refused to comment, but he gave us an idea, because he said this could come before him for constitutional interpretation, because he sees the whole thing to be quite, problematic. Why that he wouldn't want to go further? Because I understand the conflict of interest in case the matter comes before him. But the long and the short of it is that I had an engagement again with UNDP officials in Botswana. I understand that they're working with the Prime Minister's office to see how they will disentangle the situation that you find yourself and enable recommendations of my commission to the UN to be considered in terms of how they will streamline the competition among others without the mandate and resolve the problem. But I think the aspect where Ruth discussed concerning human rights is for all of us. There are so many other angles of human rights that can be hived off to others without making you lose your role in terms of your particular mandate. But it needs to be done very neatly and clearly so that there shouldn't be any mission creep or overlap. That is the part I would like to clarify. And then quickly to the different legal frameworks that establish how we operate. I'm very much aware of the Ugandan tribunal system. It's quite, they are the only ones with that, at least within the context of Africa. But there are other variants which also seem to work. For instance, in Ghana, when it comes to infringement or breaches of the code of conduct, the constitutional code of conduct, it is only my commission that can investigate and take remedial action against any public officer, from president to chief justice to the lowest. The courts, by the Supreme Court's own interpretation, are not, they have no jurisdiction over that. So we have this peculiar jurisdiction where and so because of that, system, when we are having constitutional code of conduct matters, like assets declaration, like conflict of interest, among others, because you would want the procedure to be as stringent as possible, just because there could be judicial review. But there is no original jurisdiction of the courts when it comes to that. We are the only ones actually with the original jurisdiction. That's to tell you every country and how it decides to position itself. And when it comes to whistleblower victimization complaints, we again are the body that can only investigate victimization, and when we conclude, the orders are that of a high court. So you can only move to the Court of Appeal. And that is, again, another judicial tweaking. Depends on the country and where you are operating from. So just to put this in context from my side. Thank you.
Thank you very much, Chairperson Wita, for that. I think also definitely there's room for bilateral engagement after the session. In the interest of time, we'll quickly move to Honorable.
Merci. Le docteur, ce n'est pas une question comme telle, mais oui, c'est une question parce que on m'a demandé comment la manière dont les NDH peuvent appuyer pour relever le défi de la ratification. Il a donné l'exemple des îles Comores qui ont bien travaillé pour appuyer pour qu'elles puissent avoir la ratification. Ici, j'ai la chance parce que mon vice-président, avocat de plus de 20 ans d'expérience, mon vice-président des îles Comores, je ne savais pas concrètement comment ils ont travaillé ensemble pour décrocher la ratification. Et à titre d'information, pas mal de pays n'ont pas même signé, n'ont pas signé, ils n'ont pas ratifié, et d'autres ont signé le document mais n'ont pas ratifié. Et chaque fois que nous nous réunissons au Parlement panafricain, le bureau nous donne toujours, nous rappelle de travail les autorités à ce qu'ils puissent ratifier le protocole de Marabo. Mais jusqu'à maintenant, les résultats ne sont pas satisfaisants parce que nous venons de passer un bon moment sans qu'il y ait aucune ratification, 2 ans, 3 ans, sans un ajout. Chaque année, nous avons commencé, c'est la deuxième année, ça sera la 3e année, où nous réunissons avec les organisations de la société civile. Il y a un forum qu'on appelle Forum des organisations de la société civile du pape. Là aussi, nous essayons de leur demander, arriver au pays, de travailler avec tout le monde pour mettre une pression. Mais souvent, Comme vous le savez, le protocole de Malabo contient beaucoup de réalités très politiques qui touchent même le Parlement vraiment à la signature devrait être un Parlement très fort qui peut sortir des décisions à l'encontre même des gens qui pour la plupart, la bonne gouvernance n'est pas au beau fixe. Dans certains pays même, on nous dit nous n'aurons pas signé à cause de ABCD. C'est pourquoi il est difficile. La fois dernière, on nous a demandé qu'il faut fournir pourquoi votre pays ne signe pas le protocole de Malabo. Nous sommes à rêve. Pour la première part, nous avons demandé à nos ministres et à les relations extérieures et à la coopération internationale pour demander pourquoi le protocole de Malabo n'est pas à la table du Parlement. Donc nous continuons à faire du travail. Je profite de cette occasion aussi pour vous dire de continuer à fournir des efforts, de nous appuyer pour que nous puissions décrocher la signature et aussi les ratifications du protocole de Malabo. Je vous remercie.
Thank you very much, for clarifying further the efforts of the Pan-African Parliament and the challenges the ratification of the Malabo. I think on that note, I would like to bring this panel session to an end. And please give our panelists a warm round of applause. No, it's not lunch yet. The chairperson is asking if it's lunch. We have one more presentation before we go to lunch. We are a bit over time, but we'll try.